Hello from Jacksonville, Florida. I'm sorry I can't be with you today in Indianapolis, but I'm sure you're having a great time and you're now getting to see me via video. I've never really done this before, but I'm happy to be able to accommodate your panel today to talk about the constitutionality of state outdoor advertising acts that are under attack here in the United States under the First Amendment. So, first question, I think you probably know the answer to it already, is what do the political signs of Ron Paul and Donald Trump have in common? And the answer to that is, first, they're both central to challenges to the outdoor advertising acts in Texas and Tennessee. Second, they're both examples of non-commercial speech by the persons that own or control the sign structures on which these sign messages appear. And non-commercial speech is receiving additional attention from the courts after the Reed versus Gilbert decision some 2 years ago by the U.S. Supreme Court. As of today, subject to further appeals, the outdoor advertising acts of Texas and Tennessee have been opined by judges to be unconstitutional. In Texas, the initial decision was by a three-judge panel of an appellate court in Austin, Texas, and is currently the subject of an appeal to the Texas Supreme Court. In Tennessee, the opinion was by a federal district judge based in Memphis, Tennessee, who has not yet entered a final judgment as of the date of this taping, but his final judgment is expected to be appealed to the U.S. Sixth Circuit later this year. Will there be similar decisions by other courts dealing with other state outdoor advertising acts? The answer is probably, and probably, not just probably, almost certainly. Is there a lesson to be learned now? Yes, and I'm here to tell you that every state through its state legislature should be looking closely at appropriate amendments or modifications of their state outdoor advertising acts in order to avoid the outcome that we've seen in Texas and Tennessee. First, there needs to be a severability clause that's very specific to upholding that portion of a Billboard Act or Outdoor Advertising Act that pertains to commercial speech. In the case of Reed versus the town of Gilbert, Arizona, the decision dealt with non-commercial speech. It was dealing with a municipal ordinance that could be amended in a short period of time if need be, unlike a state statute that depends upon either a legislature that meets only once a year, or in the case of Texas, meets only every 2 years. And of course, it's very different to amend a state statute than a local ordinance. The Reed versus Gilbert case was briefed in the year 2014. Oral arguments were in January of 2015. I know Eric Rubin is with you today, and Eric and I were both in the courtroom and we watched the oral arguments, and I think we both had the same impression of how those oral arguments played out. The decision was released in June of 2015, almost 2 years ago. And since then, the sign law in America has been really turned on its head. The way we used to think about what was content-based is not the way you have to deal with what's content-based today. Back many years ago, those of us who practice in this area and help ordinances be crafted to withstand constitutional scrutiny would deem a sign ordinance that dealt with Republican signs differently than Democrat signs dealing with elections to be a clearly content-based regulation. But political signs or election signs as a category was not really thought to be a content-based regulation as compared with temporary directional signs or free expression signs. Those would be a different type of sign category that had a whole bunch of different considerations on how you treat them for purposes of the number of signs, the setback, the duration of how long the sign can be displayed. they were really not deemed to be, as between those categories, to be a content-based distinction. But after the Reed versus Gilbert case, these different types of categories of non-commercial speech are a content-based distinction requiring strict scrutiny in order to survive. And what is strict scrutiny as compared to a lesser standard of review of what's called intermediate scrutiny, not surprisingly? Well, strict scrutiny, you have to establish a compelling government interest in the regulation of speech. And one person described it as the ability to survive strict scrutiny is like surviving a stomach wound in the Civil War. Highly unlikely that you would survive. And so the same is true with strict scrutiny. It's very difficult to establish a compelling government interest because aesthetics is determined to be a substantial government interest, but is not so far a compelling government interest. So the mere fact that you're dealing with a subject matter of aesthetics, such as the Highway Beautification Act, doesn't get you where you'd like to be in order to uphold the regulation of speech. A lot of people would think that the difference between a substantial government interest, which again, aesthetics is a substantial government interest as determined by the courts, and a compelling government interest wouldn't seem to be that much different. I mean, if you take an ordinary person off the street and say, what's the difference between substantial and compelling, they'd probably look at you and say, what are you talking about? Aren't they the same thing? But the courts have come up with a standard of a compelling government interest to be something that's very difficult to meet. In Texas, the problem goes back to the late 1990s when the Texas Outdoor Advertising Act was amended to add a provision that dealt with political signs or election signs. Had that amendment not been made in the 1990s, it's unlikely that there would have been the outcome in what's called the AUSPRO, A-U-S-P-R-O case that we have today. And so the Texas legislature is meeting right now, and maybe by the time of your conference next week, the Texas legislature may have passed an amendment to the Texas Act. My own thought would be to repeal the provisions in the late 1990s that were added to the Act, and see if that wouldn't satisfy the Texas Supreme Court in connection with the ongoing appeal. There are other provisions that various people have suggested. I know that Scenic America has made some suggestions. I've made some suggestions. The current provisions that are the subject of legislative consideration are, they might work, they might not work. I think Eric Rubin may share his own judgment as to the efficacy of the Texas legislative, what's being considered by the Texas legislature as we speak. In Tennessee, the Tennessee legislature will soon be adjourning. There's not yet legislation proposed to amend the Tennessee Act, but I think there was a clear signal by the Tennessee federal district judge in Memphis as to what needed to be done. He said at the very end of his opinion that he could not apply severability and save the provisions that regulate commercial speech based upon the current Tennessee Act as written. And this reference to as written was his way of signaling that if the act were written in such a way that it was clear that the Texas legislature intended for severability to apply to save those provisions of the Tennessee Act that pertain to commercial speech, he would have done it, and he would do it, and he will do it. My hope is, and I don't think it's going to happen, but my hope is that the Tennessee legislature will act in time to add a severability provision to the act so that before a final judgment is entered, the parties can tell the court that the Tennessee Act has been amended, the severability provision has been added, and a provision that makes it very clear that it's the intent of the Tennessee legislature that severability of the commercial speech regulations survive should any other portion of the Tennessee Act be ruled unconstitutional. In that way, the state of Tennessee can still appeal the decision to the Sixth Circuit, but they will have left in place a regulation of commercial speech that really needs to survive in order to protect the landscape. I don't think it's enough to have a stay, although a stay would be good. But the problem is copycat suits, and we may see a plethora of copycat suits in Tennessee and maybe elsewhere in the country where there is not the protection of a clearly written severability clause. And at the end of my remarks today, I'm going to read to you a severability clause, but I will hope that it could be displayed on the screen and that Ron can pass a handout of what I believe would be an appropriate severability clause to be added to any state outdoor advertising act. I'd be remiss if I didn't also mention the substitution clause, which I've also recommended to officials in Tennessee that they consider adopting. Those of you who may be there from Rhode Island or California, if there is anyone there from Rhode Island or California, will know the importance of a substitution clause in the State Outdoor Advertising Act because of past litigation in federal court dealing with the constitutionality of the Rhode Island Act and the California Act. A substitution clause simply says that wherever commercial speech appears, you can substitute a non-commercial message. That way, non-commercial messages are not being disfavored in favor of commercial messages when you have the right to substitute a non-commercial message at any time for a commercial message. And there are plenty of examples of very solid substitution clauses that have been adopted. In fact, you can now look to the California Act and the Rhode Island Act to see how that was accomplished. Any state that is not proceeding to amend their outdoor advertising acts to ensure the presence of a substitution clause and a severability clause are acting contrary to the interest of the public and contrary to the interest of the Highway Beautification Act. I know Hannah Needleman is with you today. Hello, Hannah. Newly assigned to looking at the Highway Beautification Act vis-a-vis the states, and so for Hannah it's a little bit like drinking from a fire hose with all that's going on today. But I hope Hannah Needleman will be able to give you good, sound advice as we proceed further. I would also encourage you to listen carefully to Eric Rubin. Eric and I disagree on many matters of policy, but on matters of law. In this particular subject, I think we're a lot closer than people would believe, although I really do believe there should be legislative fixes happening now across the country in state legislatures by either the Department of Transportation or the Attorney General's offices in every state, consulting closely with First Amendment experts and colleagues of mine, for example, or colleagues of Eric, people that really know the area of the First Amendment and have a lot of experience in defending governmental interest against constitutional attack. I'm going to go ahead and read to you because I'm not sure how this final product is going to appear. Maybe there'll be something on the screen that will show while you hear my voice, but a severability provision similar to the following would be appropriate, beginning with the title Severability of Provisions Prohibiting and Regulating Commercial Outdoor Advertising Billboards. If any part, section, subsection, paragraph, subparagraph, sentence, phrase, clause, or term or word of this, and then insert the name of the chapter or the title or both, is or are declared invalid or unconstitutional by the valid judgment or decree of any court of competent jurisdiction, the declaration of unconstitutionality shall not affect the prohibition or regulation of outdoor advertising commercial billboards in this, and then again insert the title or the chapter of the State Outdoor Advertising Act, and then end it with the following sentence. It is the intent of the legislature that the prohibition and regulation of off-site commercial billboards be severed and saved in the event of the declaration of unconstitutionality of any portion of this chapter title. Again, you'd have to add whatever the chapter title is for the Outdoor Advertising Act in your state. I'm happy to answer the phone and give you my best opinion on any of these issues. If you wish to contact me, my direct line is 904-346-5537. You can just put my name in any Google search and you'll quickly find me at Rogers Towers, PA in Jacksonville, Florida. I'm sitting in one of our conference rooms today. Behind me is the St. Johns River. Maybe you can see our stadium in the far background. So enjoy yourself in Indianapolis. It's a great city. I wish I could be with you. Have a good conference. Thank you.